Welcome back to the regulation on inspection and investigation. It's called the Inspection and Investigation Regulations 2017. It's a regulation. We finished one part. The second part is on investigation. The first we spoke was inspection. The next is investigation. Now you'll notice that there is a lot of commonality between the provisions of regulations for inspection and investigation. But there are some things which are incremental in investigation which we can go through. So it's regulation number 7. It says the board may conduct investigation of a service provider under section 218. 218 was the same section that spoke of inspecting authority or investigation authority. The board, for the purposes of this regulation, may by order direct an investigating authority to conduct an investigation of the affairs of the service provider. What's an investigating authority? It is a group of officers, officer or a team of officers of the board which has been directed by the board to conduct an investigation. Again, what will the order contain? Scope of investigation. Who all are going to investigate? What is the timeline for investigation? What is the interim report? What is the final report? How are they going to report on the progress of investigation? So it's virtually the same thing that was there in inspection. The board and the investigating authority shall make every effort to keep the investigation confidential. The same provision, and to cause least burden or disruption to the service provider under this regulation. It's the same clause. Then we come to the board may at any time modify the order to enlarge the scope of the investigation. Please put a star here because in an inspection order, this particular clause of the ability to enhance the scope was not there. Then conduct of investigation. The investigating, star this, it is a statistical point. The investigating authority shall serve a notice of investigation to the service provider at least 10 days before the commencement of the investigation. This is the same specification. Again, they had prescribed 3 conditions. Okay, 1 where there is a scope for falsification, 2 for an undue delay, 3 reasons recorded in writing. They can dispense with such notice to the service provider. Same. Then the inspecting authority, here the investigating authority will require the service provider or associated persons to submit records. Investigating authority may also visit offices just like inspecting authority. It shall be the duty of a service provider and an associate person to produce before the investigating authority such records in his custody and to furnish such statements and information same. They shall also allow the investigating authority to have access to the premises to the by such service provider or by any other person and extend the facility for examination to the investigating authority. Then the investigating authority shall examine and record statements and shall be read over to and be signed by the person examined. Please star that. We didn't go through this there. Okay. If you notice, this is not there in inspection. Okay. Here, please note 7. Notes of any examination shall be recorded, read to and signed by the person examined. Then the investigating authority may keep in its custody any record, provided it may calls for these records whenever it is necessary and give certified copies. So they basically say you can take the record, give it back, but you can have the right to ask for certified copies later. Now, the remaining are new. After 7, go to 9. Go to 10, where in the course of investigation, the investigating authority has reasonable grounds to believe that the records may be mutilated, destroyed, altered, falsified or secreted, may make an application to the competent court to order for a seizure. Okay, this is very important because this was not there under inspection. In inspection, you need not get statements signed. You did not have the power of seizure. But for power of seizure, it can be exercised only when you make an order to a competent court and having the jurisdiction for the order for seizure. So this is on what grounds? Where the investigating authority feels that there is a scope for falsification, secreting, mutilation or destruction, then they can ask for the seizure. So star this. After considering the application and hearing the investigating authority, the competent court may by order authorize the investigating authority to enter with such assistance the place or the places, search, seizure. So 10, 11, 12, 13 of Regulation 8 provide for the rights to seize records by an order of a competent court to enter, search, seize. The investigating authority may requisite the services of police officer or any other officer to assist him in such search or seizure. Every search or seizure shall be carried out in accordance with the provision of the Code of Criminal Procedure relating to searches and seizures made under that code. So please remember, pretty identical to inspection. Incremental is signing of the statement, search and seizure, competent court. Then we come to the next regulation, which speaks about the same thing. There you had an interim inspection report. Here you have an interim investigation report. So he will submit an interim investigation report. But if there is a cause for alarm under section 222, then the board shall make a reference to the disciplinary committee. 222 is grounds for suspension or cancellation of the certificate of registration. On consideration of the interim investigation report, the DC can pass interim orders on the matter. The interim order will be valid only for 90 days, identical to inspection. Then you have an investigation report. If you remember, under inspection, you had to give a draft report. Even under investigation, there is a draft report. But in inspection, you had to give a copy of the draft report to the service provider who was being inspected, correct? Requiring their comments within 15 days. Here there is no comment and all that. Straight away, the board shall examine the draft investigation report as to whether the investigation is complete or whether they require further investigation and advise the investigating authority within 15 days of receipt of the draft investigation report. After taking into account the advice of the board, the investigating authority will prepare the final, the investigation report. So please star 10(2) and say there is a difference between inspection and investigation here, because this report need not be given for comments to the service provider. Then, chapter 4, the consideration of the report itself. The board shall consider the inspection report or investigation report expeditiously. If the board, after consideration of the report, feels sufficient cause exists to take action under 220, full 220, 2, 3, 4, 5 or section 236. What is 236? 236 is actually the section which deals with trial of offences by a special court. So whether they need to go to a special court to try this offence, they will decide here. So in your regulation, go to 236, circle it and write special court. And issue a show cause notice in accordance with regulation 12 to the service provider. Show cause notice, again, standard show cause notice. Why am I issuing the notice? How should he respond to the notice? Within what time should he respond to the notice? What is the alleged offence? What is the alleged fact? Same. For the purposes of subregulation 1E, the board shall take into account the following factors, but not limited to: nature and seriousness, deliberate, reckless or negligent, consequences and impact of the alleged contravention, unfair advantage, loss caused, or conduct of the noticee after the occurrence of the alleged contravention. Okay? That is, for when the showcase cause notice, he has to say what action or direction I am proposing. There, to write in the show cause notice, I am proposing the following. You should take into consideration the behavior of this person after the alleged contravention. the unfair advantage that the noticee has gained, loss caused or likely to be caused as a result of the alleged contravention. Because that only determines the magnitude of the offence for which you are issuing a show cause. The show cause notice shall provide 21 days for the noticee to make a written submission. Please star it. It shall state, if the noticee does not respond, it will be disposed based on material available on record and ex parte decision. It shall enclose copies of relevant documents and extract. It shall be served at the registered office by registered acknowledgement due and by an email. Okay, please star that. You only have to remember 21 days is the time given for response to a show cause notice under an inspection or an investigation. Disposal of show cause notice by a reasoned order. Order shall be within 180 days. See, everywhere disciplinary committee will have 6 months or 180 days. That's the way it is defined. Okay? Even a DC of the IPA, here DC of the board, everybody has 180 days time. Appellate authority, 30 days. Okay? To dispose an appeal. The order under subregulation 1 will provide for, where the show cause notice itself is wrong, closure, warning, 222(3)(4), 5, and any other direction as may be considered appropriate. 222(3)(4), 5 are nothing but suspension, cancellation, monetary penalty 3 times, 1 crore, disgorgement, restitution. 2, 3, 4, 5.
Okay.
Now where they cancel, he has to continue until another service provider comes in and he is able to take over the activities of this service provider. We then come to the last part on restitution, where a direction has been issued to any person to disgorge the amount under 224. The board shall endeavour to realize the amount of disgorgement expeditiously. The board shall, as soon as after realization of the amount of disgorgement, invite claims from the public announcement from persons who have suffered a loss on account of the contravention, who are seeking restitution. Restitution is to restore. A person referred to in subregulation 2 shall submit the claim in form A within 30 days of public announcement. It shall scrutinize within 30 days and it shall distribute the amount within 30 days. So please remember, it's 30-30-30, where the board shall invite by a public notice people who think they are eligible for the restitution. They will submit the claims in form A. Within 30 days they will verify the claims and they shall submit within 30 days, they will verify in 30 days and the settlements shall be done, which is the disbursement proportionate within 30 days of the claim. So here we have form A, which is the claim and a verification that this person has to say, I verify and affirm that the claim is true. So what we went through now was the inspection and investigation regulations under section 217, 218, 219, 220. This is a separate chapter by itself, if you recollect. This was chapter number 6 under part 2. So you can please write on the top, chapter 6, part 2. Associated person, essentially an officer, employee. Inspection can be done by the board, suo moto or based on a complaint. For inspection, you will have an inspecting authority. 10 days advance notice, but not mandatory in certain cases. Provide all kinds of support needed, including documents, access to premises, take copies, return copies. Interim inspection report. Alarming circumstances 222. DC can pass interim orders valid for 90 days. Then inspection report will be given in draft. For comments of the service provider, within 15 days he has to give his comments. Final report will be issued. Within 15 days they will say whether the inspection is over. Investigation. authority gets constituted. Same under inspection. Added features being the right for search and seizure. And the statement has to be signed. So he can also take the directions or take assistance of the court for this search and seizure. It shall be under the Code of Criminal Procedure. Interim investigation report, same as interim inspection report. Then draft inspection report. No need for comments and remarks of the service provider. Goes straight into final investigation report, 15 days. Board shall consider the report, issue a show cause notice. What are the contents of the show cause notice? Gravity of the offence will be considered in determining what allegation they want to put in the show cause notice, the actions and directions basically. He'll have 21 days time to respond to the show cause notice. Then the DC will, through a reasoned process, DC of the board will dispose of the hearing, and it will be 180 days. And the order can provide for 222, 3, 4, 5, okay, or under 236(2), which is a special court, right? And then the order shall not become effective unless 30 days have lapsed from the date of order. It really doesn't provide in this regulation for an appeal, but I presume there is a right of appeal against this order because it's made by the board's DC only. This is after consideration, yeah, the board. So I'm not sure, there must be an appeal to NCLAT against this order. Then restitution, they will issue a public notice. 30 days the person has to submit his claims, 30 days we have to verify the claims, and 30 days we have to complete the disbursement. So with this we come to an end of the inspection and investigation regulation. This is a fairly important regulation.